with your Scott. Please state your name, spell your last name for the record.
First is Scott, last name McManus, last name is Spelling.
You're ready, counsel.
Thank you, Judge. Good morning, everybody. Can you tell us your name again, please?
My name is Scott.
And Mr. McManus, can you tell the jury how you're employed today?
Yes, I'm currently with the Michigan State Police. Post commander.
For that posting in Houghton Lake, can you tell us a little bit about what your job assignments were?
Sir, prior to taking the assignment back in the Uniform Division, the Houghton Lake Post, I worked at the governor's office. In the section unit. I was Governor Whitmer's detail commander. Signed up. Transferred back in uniform. 14 months ago.
I want to take you back in time, if I could, to the year 2020. Would that have included your assignment in the governor's protection detail?
That's correct.
Excellent. Tell us a little bit, just generalities, if you will. I mean, the governor of the state of Michigan, has it been the practice of the Michigan State Police to provide a protection detail for the governor over the past several decades?
That's correct. Our department historically provides protection for the sitting governor and their family members.
Okay. Is this protection both, during business hours and after?
Yeah, it's all encompassing 24 hours a day, 7 days a week. We provide protection. However, the sitting governor travels, and as well as the residents that they reside.
Okay. You're familiar that Governor Whitmer had a vacation property near Elk Rapids, Michigan. Is that correct?
That is correct. I'm aware.
Okay. Going back to 2020, tell us, if you will, the troopers who protect the governor. I mean, are they? What's their mission? Their simple statement.
The umbrella of the mission is obviously the protection, providing protection, transportation of the governor and all family members. We transport the governor to whatever venue that she visits, and that goes along with her cottage there north of Elk Rapids.
Okay. The going back to 2020, did you receive some information from the Federal Bureau of Investigation that there may have been individuals looking to either harm or kidnap the governor?
That's correct. We were giving intelligence information, sensitive information regarding the safety of the governor and potential threats towards her and the family.
Without going into means and methods, did this change the way in which your detail protected our governor?
Without a doubt. We do have common practices. It's how we carry out our maneuvers and our day-to-day duties. As a result of the threat, we had to be very aware of not only the governor's safety, but our safety for us to continue to provide protection. Take measures, change the normal.
Troopers that work in this detail, is this a volunteer or a type of assignment, or is this something that they can be required to perform?
When they're selected for the position, they are required to be conscious of their environment. That involves threat levels, traffic, a myriad of things, but it's all encompassing. That's correct, and it's a select type position.
Okay. Would these troopers be expected to give their lives if required to do so?
Not only do we give that oath when we join the department, but the governor's safety, it's very well made aware of. We may have to compromise our safety in order.
In terms of the information that you received back in 2020 regarding the threat assessment to Governor Whitmer, I mean, this raised any concerns in terms of your leadership or your oversight of the detail?
That's correct. Being the detail commander, I had direct line of communication with the governor and other staff members that were near her. And we would have regular briefings. Here with up-to-date information with regards to what we were receiving from the intelligence.
During the calendar year 2020, did you have the opportunity to speak with Special Agent Henrik Impola from the Federal Bureau of Investigation?
I did.
And he's the gentleman seated at council's table here to my right.
That's correct.
Okay, and were there times that he was providing you and your detailed direct information about threat assessments to the governor?
On a regular basis, that's correct. Agent and I spoke quite often.
Was there an occasion in April, if you remember, that there was a protest at the Capitol that you were advised of?
That's correct.
Does the governor have a ceremonial office within the Capitol building?
That's correct.
Does the governor regularly occupy that office?
Not routine. No.
Okay. The information that you got from Special Agent Impola back in April, was it concerning the possibility of the governor being in the Capitol building that day?
That's correct.
Okay, was the governor there?
No, she was not.
Okay. I mean, is this an example of the kind of communication that you and you had with Special Agent Impola?
That's correct. With the information provided, we would not expose Governor Whitmer to any type of threat. And that being the reason why we were nowhere near the ceremonial office there.
Moving deeper into the year of 2020, in August of 2020, did you receive information from Special Agent Impola that the governor's summer cottage was going to be surveilled?
That is correct. I was made aware of that.
Did that change in terms of, you know, the detail that you were responsible for protecting the governor and her family? Did that change some of the behavior of that detail when that occurred?
Yes, the frequency in which that cottage was visited by she and family were limited due to the threat.
Okay. Tell us a little bit, if you would, when you received the information from Special Agent Impola, you know, what did you do with the information that you got? How did you move it forward?
Pretty much all the information I received from Agent Impola, I would go directly with the governor and her staff and explain to them threats in which I was informed of, and I would directly communicate that with the governor and chief of staff. Give my recommendations as to what we should do week or the weekend in lieu of these threats.
Mr. McManus, the protection of the Michigan governor, I mean, this is something that goes back, I think you mentioned earlier in your testimony. Correct.
That is correct.
And I mean, did you, I mean, this is did you work for another governor besides Governor Whitmer?
I did work, or I did provide protection for the former governor, prior to Governor Whitmer, and that was Governor Rick Snyder. I was also on his protection.
All right, thank you very much. Nothing else, Judge.
Any cross?
Couple questions. Sorry, lieutenant or trooper?
That's correct. First Lieutenant, it's,
McManus, right? I don't know.
that's correct.
I just have a couple quick questions for you. The information that you received regarding these threats, those came directly from the FBI, correct?
Came from Agent, I think it was my direct source.
Very well. So you communicated directly with Agent Impola, correct?
That's right.
Ladies and gentlemen, I promise you I'm symptom-free. I have did another test last night. It was negative, so I kind of want to put you at ease. I'm going to wear the mask today, but I just want everybody to know that I've taken every precaution. I don't want you to be. So
You had to get the doctor's okay before you could come back.
Yes,
We
believe
wouldn't
me,
want
I'm
him
not
back.
coming in here willy-nilly trying to put you guys, I promise you that. So the call, the information didn't come in as a result of people calling in and threatening the governor, correct?
I really don't know the means in which these were relayed
That-
to Agent Impler.
That's fair. That's
Yeah.
very fair.
Yeah.
You have no personal knowledge that someone actually called in and threatened to kidnap the governor or threatened to harm the governor related to these incidences. Is that a fair statement?
It's accurate. The information that Agent Impler was provided was accurate enough for us to take it seriously.
Absolutely, but that's where you got the information, correct, as Agent Employee?
That's correct.
The, you said that you got some information about a protest in April, and then the other information they talked about was in August, correct?
I'm aware of the April timeframe. August, I cannot pinpoint as to which threat or what I was advised on in August of 20.
I believe the prosecutor asked you a minute ago if you received some information from Agent Impola in August regarding the surveillance of the summer cottage of the governor. Do you recall him asking you that?
Yeah, again, I'm not familiar. It was in August, but I was given information regarding the summer cottage. Yes.
And this is Mr. Beller right here. You ever seen Mr. Beller before?
Not in person, no. Okay.
You ever spoken to Mr. Beller in person?
No, I haven't.
Anything?
Just one, Your Honor. Lieutenant, you testified a moment ago that you were advised about one of the protests in April. Is that correct? April of 2020?
That's right.
There were multiple protests in April of 2020. Is that correct?
It was weekly.
Okay. Which date was this one that
I don't recall the specific date, but I recall the largest being the initial, I guess it was quite termed as a lockdown.
nothing further? Your Honor.
Thank you, Trooper, Lieutenant. Thank you. You're dismissed unless you have anything else.
No, sir. Thank you.
Next witness.
Coming up, Judge.
Judge, we're going to call our next witness and it's the undercover agent. And so we were asking about the cameras being turned off.
Yeah, we'll take the one, Corey, turn the one off. The face is here. You can leave the one on for the attorneys.
Thank you, Judge.
We tell the whole truth, nothing but the truth. Count it whenever you're ready.
Sir, tell us your first name.
Good morning. My first name is Mark.
Spell it for us.
M-A-R-K.
Okay, thank you. Sir, how are you employed?
I'm a special agent with the FBI.
And in what capacity?
Just like any special agent with the FBI, I'm primarily an investigator, but one of my secondary duties or collateral duties is as an undercover employee with the FBI.
What does an undercover employee with the FBI do?
So we're an investigative tool used by the Bureau. We're not the case agent, so we wouldn't be running the investigation, but we would be asked by the case agent to come in and in alias, meet with targets or subjects of investigation
How long have you been an undercover agent?
since 2015.
And how many years have you been a special agent with the FBI?
I started in May of 2009.
Do you have some kind of special training and experience to do that kind of a job in your undercover capacity?
Yes, ma'am. There's a certification process that the FBI puts you through. It's a training process as well as on-the-job training. Through the undercover.
You said that you are part of operations in an alias capacity. Can you tell us about that? Can you tell us what a legend is and tell us about that?
Certainly.
a legend is essentially the thing you tell the subjects about yourself. So in this particular case, I was portraying someone from the Upper Peninsula of Michigan who had similar feelings to and wanted to do similar things that the group and individuals that I interacted with in this operation did.
And when did you begin your participation in this operation?
June of 2020.
Do you have a job that that was part of your legend?
I did. It was, we never really talked about it, but my legend was that I was in commercial landscaping in the Marquette area.
And you said you began in June of 2020. Tell us about your introduction to the group and how you got into it.
I was introduced through an online undercover employee, so another FBI employee who was interacting with subjects of the investigation online through Facebook and other social media like that. She was someone that told a person named Adam Fox that she was my girlfriend and that I had similar aspirations to what Mr. Fox and his girlfriend wanted to do. She asked Mr. Fox's girlfriend if she would pass my contact information to Adam, which Mr. Fox's girlfriend did. And then Mr. Fox and I initiated a text message relationship in late June 2020. And then we met for the first time on July 3rd of 2020.
So you said you initiated a texting sort of relationship. Did you use a specific encrypted application to do that?
We did. We used an encrypted app called Wire at the time.
And you communicated directly with Adam Fox, is that right?
Yes, ma'am.
Okay, not with any of these three subjects in the courtroom, correct?
No, ma'am.
Okay, thank you. And you said the first time you met him was around July 4th weekend of 2020, is that right?
Correct.
Okay, and can you tell me, you said you set that meeting up through Wire, is that right?
Yes, ma'am.
Okay, and so what did you do?
So I had told Mr. Fox I was going to be in the Grand Rapids area, which is where he lived and worked. So he invited me to where he was employed, which is a place called the Back Shack. It's a vacuum sales and repair store. Showed up the afternoon of July 3rd, introduced myself to Mr. Fox. There were a few customers in the store at the time. We waited for them to leave. We had a brief discussion upstairs about whether I had a cell phone on me. I told him that I did. He asked me to leave it in the counter area. And then he took me down into the basement of the Back Shack, which was, as I later came to understand, where he was living part-time.
Okay, and you said you went into the basement. Did you go through a door on the floor of that, of the first floor?
Yes, ma'am. It was a trap door, similar to any cellar in the Midwest that you might go down into. So you raised it, and then there were a set of stairs that you went down.
And so he employed some operational security measures, is that right?
You did, yes, ma'am.
Okay. Did you have a recording device on you at that time?
I did.
You left your cell phone upstairs, but you had a different recording device on your person, is that right?
Correct.
Okay. And when you went downstairs, what happened?
He talked about the plans that he had, specifically that he wanted to take the Michigan state capitol by force and was gathering people and working with people to do just that.
Did he talk about at all the kind of force he wanted to use?
Violent action against the legislators at the Capitol to kidnap them and then either put them on trial or ransom
Ransom them for what?
the government.
And you said he indicated he had a group he was working with, is that right?
He did.
Okay, and what did he tell you about that?
He told me he was working with several different people or several different groups to include a group called the Wolverine Watchmen.
And you've previously reviewed your recording, is that right?
I have this.
Okay, exhibit number 149. I'm going to move for its admission, Judge.
Any
No objection. Objection. Standing objection.
149 is admitted.
Thank you. If you could play it for us, and then I'll ask you some questions about it.
We're operating with a group called Wolverine Watchmen.
Okay.
They're not very well liked. I have a lot of people in the state, mainly because they're not legal records, things like that. So,
Yep.
these guys are very fucking like full person. You'll see some who focus at the rallies, but then they got other guys walking around grading, it's like you, Woody, Smoke.
Right.
They're like walking around, they got backpacks on, they got folded with some compacts, and it's like 500 fucking rounds. And we are.
Right.
For sure, there.
Was this a part of the conversation that you had with Mr. Fox?
Yes, ma'am.
Okay. And did you take him seriously with the way, with his tone and his demeanor?
I did.
Did you take what he was saying seriously, that he actually wanted to go do this violence?
Yes.
I'm gonna, you can take that down, thank you. I'm gonna jump over to July of 2020. Were you asked to do anything else in your undercover capacity?
Yes, ma'am. I attended a field training exercise at FTX in Cambria, Wisconsin, area, which is about an hour outside of Madison.
And what is an FTX?
It's a training. So we did live fire training, we did a shoot house or kill house. There was some medical training, essentially mimicked military, or in some cases, law enforcement training.
What was, you were asked to go to this training as part of the operation, is that right?
I was.
Right, and what was your primary focus when you were going there?
Mr. Fox, he had invited me, and then the case agents had asked that I attend the training as well.
And when did you get there?
Approximately between noon and 1 on Saturday.
Okay, and so this was a 2-day training, is that right?
It was, yes,
Did you stay for the first and second day or just the first day?
just the first day.
And so you said you got there around midday,
Correct.
okay? And what happened when you got there? Tell us about the kind of setup and explain what you did.
So as I arrived, there was a live fire training exercise taking place. So I actually had to stop as I was driving up to the property to let them finish an iteration of the live fire. So I pulled up and they were doing live fire 1 or 2 man drills where they would engage with the target, seek cover, reload, and re-engage with that target, falling back to additional cover.
And did you meet Mr. Fox there?
I did.
Okay, and can you tell us about kind of whether there were stations, how it was set up?
Yes, ma'am. So there was a range area where they were doing that live fire exercise that I talked about. And we did a kill house or shoot house later that day in that same general area. And then there was someone's home that was probably 200 yards away from the firing line, with things you would find in a home. There was a barn area. There was another station where we later did some medical training that was a little closer to the home, but probably between the home and the firing line.
How long did you stay that day?
I was there till approximately 6.
Now, you described some of the tactics being practiced. Did you see room clearing occurring?
I did.
And are you familiar with these tactics as part of your training experience in the FBI?
Yes.
Okay. And describe to us what room clearing is.
So it's using usually false walls or rooms to make entry and eliminate threats in that room, and then reform as a team, and then flow into that next room doing the same thing again, making entry into the room, eliminating any threats, regrouping, and moving throughout the course of the building. It would be how a law enforcement tactical team or a military tactical team clears a building, home, business, whatever they're clearing.
And did you see that kind of training occur?
I did.
What about tactical shooting?
Yes, ma'am.
Okay. What about reload drills?
Yes, ma'am.
What are reload drills?
So again, that would be what they were doing as I arrived on the property. They were, so they were firing, they were engaging with the target. And then as they went dry, or in some cases, did a tactical reload, which is where you, even though you haven't run out of bullets, you're reloading your weapon so that you have more bullets, so you don't run out. So that's what they were doing. And then they were practicing reloading as another member of their team was firing. They would seek cover to perform those reloads.
And you said a kill house was on property, correct?
Correct.
All right. And Did Paul Bellar attend that training? Okay, and can you identify him?
I can't. He's the gentleman in the blue shirt, blue and purple tie.
What was your contact with him at that training on day one?
Very minimal.
Okay, when you say minimal, did you see him at the training?
I did.
All right, and did you see what he was doing or engaging in?
I did.
Tell me about that.
So the two things I noticed during my time there was he was running the medical tent, essentially. There was some instruction being provided about tourniquets and what I would term battlefield or, things that relate to or one would encounter in a firefight, care under fire. And then I saw him participate in the kill house with the Wolverine watchman.
Okay, so you said you saw him participate in the kill house, and that's a tactical drill with firearms, correct?
Correct.
But you said you saw him instruct in the medical tent.
Correct.
And what do you mean by instruct? How long did you see him, or was he with other people? Tell me about that. If you can.
He was, yes, ma'am. He was with other people. There was another gentleman with him, but they were providing instruction on the application of tourniquets. That is what stands out in my mind, is tourniquet application, how to do it, how to mark it when it's been applied, things of that nature.
Okay. Do you remember roughly how long you saw this happen for?
The medical tent, ma'am,
Yes.
an hour or less.
Did you have discussions with people at training while, well, you know what, let me show you, I believe it's been admitted, exhibit 166, if you can play that. Is this kind of what you were seeing when you said that you saw Mr. Bella participate in training? And this is the kill house, is that right? Did you have discussions with other people at the training about the proficiency of the Wolverine Watchman group that had come?
I did. Mr. Fox, for one, was impressed with the proficiency of the way they moved together as a unit, their team tactics.
I'd like to jump over to September of 2020. Were you asked to do something else in this operation?
Yes, ma'am.
And what's that?
I was asked to attend another field training exercise, this time that took place in Luther, Michigan. I was asked by Mr. Fox as an undercover, and then this occasion he was asked me to attend it as well.
Okay, so you did attend, is that right?
I did, yes, ma'am.
And when you went up to Luther, Michigan, was there operational security?
Yes, ma'am.
Tell me about that.
At one point, the person brought out an RF detector, radio frequency detector, which should detect bugs or listening devices, and was using it wanding it around people at the training to ensure that no one was carrying a listening device.
Your Honor, I would just ask for clarification of who is a person, if he knows who the person is, Your Honor.
Do you know who the person was?
I do. It was Mr. Fox and another gentleman.
Mr. Molitor?
Eric Molitor. yes, ma'am.
Thank you. All right, and just to be clear, none of these three defendants were at that training in September, is that right?
That's correct.
So you talked about the RF detector, and it's supposed to detect radio frequency, is that right?
That's correct.
What other measures that you were aware of for operational security employed?
So I was aware that they were running people's license plates or attempting to run people's license plates. There was, Mr. Fox specifically was concerned about government infiltration into the group and had been told that somebody had a contact with, whether it was law enforcement or the DMV or somebody, the ability to run license plates. So they were taking steps to attempt to run license plates to see if the license plate matched to the name and the person that was supposed to.
Were there other members of the Wolverine Watchmen that attended that training?
Yes, ma'am.
Roughly how many? Do you remember? And that group that came up there, did they discuss acquiring explosives?
They did.
Can you tell me about that?
There was a separate undercover, FBI undercover agent there who was portraying someone that had access to explosives. There was a meeting during that weekend, with that FBI undercover, that I was a party to as well, where he discussed what type of explosives he could buy, and but the price, essentially gave them a menu, a price list.
Is the FBI actually going to supply explosives to the group? Tell me if you did anything relating to targeting the governor on the night of on the night of the first day of training.
Yes, ma'am. I participated in a surveillance with several other people within. Tend to include myself.
Okay, and were Mr. Adam Fox, was it Mr. Adam Fox a part of that?
He was.
And what role was he in that group?
He was certainly the person that the group I was part of was.
What about Mr. Barry Croft?
Mr. Croft was there, yes.
Okay, and did they both participate in that surveillance?
They did.
Thank you. How many cars went and did that surveillance?
3.
And again, none of these defendants were in that, correct?
Correct.
Thank you, Agent. That's all the questions I have for you right now.
Ross,
Please, thank you. Morning, Mark.
Sports,
How are you today?
fine, thank you. Yourself?
Good. Got a couple questions for you. So the first time that you met Adam Fox was in June?
Met him physically, sir?
Yes.
It was July 3rd.
That was at the back shack, correct?
Correct.
And that would have been July 3rd, correct?
Correct.
Then you went to the training in Wisconsin, correct?
Sir,
The July 3rd meeting, Mr. Beller was not at that meeting with you and Adam Fox, correct?
it was not, that's correct.
You went to the training in Wisconsin, you saw Mr. Beller there, correct? That's the last time you saw Mr. Beller, correct?
Right.
When you did all this surveillance in August, all the training and meetings from August all the way until October, you never saw Mr. Beller again, correct?
When you say all this, I didn't see Mr. Bellar again at any event I attended.
So July 11th, Cambria, Wisconsin is the only time you saw him, correct?
Correct. Yes, sir.
You testified a minute ago that Paul was running the medical. That was your testimony, correct?
Yes, sir.
And explain to me again what all the things that Paul was teaching in that medical center, if you would, please.
What I specifically remember, sir, is tourniquet application, how to apply one. There are certain ways you mark it once the tourniquet is on to indicate how long the tourniquet has been on, things of that nature. Tourniquet application is what stands out in my memory.
You recall testifying on September 1st of 2022. So a month and a half ago,
Yes, sir.
that would have been up in Antrim County, is that correct?
Yes, sir.
And that would have been a preliminary exam, correct?
Yes, sir.
And that would have been under oath, correct? And again, the purpose of a preliminary exam is to determine whether there's probable cause to bind the case over the circuit court, correct?
If you say so, sir.
Oh, but if you don't know, and that's fine. And so if I ask you a question you don't know, just let me know, okay? You understand my approach?
yes.
The first one. There's the one.
Page 4 of 4. Thank you.
Thanks.
And again, you would agree with me that September 1st was a mere 6-7 weeks ago, correct?
The calendar is what it is, sir. Yes, sir.
Would you please go to page 21 for me?
You bet.
We're going to start on line 15. I'm gonna ask a question, and then I'm gonna ask you to give the answer that you gave at that preliminary exam. If you could please do that for me. You with me?
Yes, sir.
You're on page 21, line 15.
Yes, sir.
Here's the question. Okay, was there any other type of training going on this day there? What's your answer?
Wait, give me the line again.
Okay, I'm sorry.
Nope. this is-
So we're page 21. We're gonna start at line 15. We got the Q&A.
Oh, the-
I'm gonna read the question. Let's start over again. I'll read the question for you, and then I want you to read your answer that you gave in court on September 1st of this year. Question. Okay, was there any other type of training going on this day there?
There was, yes, sir.
Can you describe that for us?
So after live fire exercise took place, I participated in some medical training later on that day. There was general shooting as well after the medical. And then there was some room clearing exercises towards the end of the day.
Question. Okay, before we get to that, this medical training, can you describe for us who provided that, if you know? What's your answer?
I don't recall at this time, but it was primarily how to deal with gunshot wounds, specifically putting on tourniquets, things like that.
So on September 1st, you testify that you don't recall who was putting on the medical training, correct?
I said I don't specifically recall at that time.
And today you're testifying that it was Mr. Beller, correct?
Correct.
You met with Mr. Fox numerous times. Is that a fair statement?
I guess I'd ask you to quantify numerous.
How many times do you think you met with him?
Met with him on July 3rd. I met with him sometime at the Cambria, Wisconsin FTX. I met with him in August, and I met with him 2 days in Luther.
And again, Paul wasn't with you for any of those meetings with Adam Fox, correct?
Other than
Other than the training in Wisconsin,
correct,
he wasn't present with you for any of those meetings, correct?
correct. He was only present. The only time he and I were present at the same place that I'm aware of was in Cambria, Wisconsin.
And when you pick it back up again with Adam Fox in August, and from August continuing on, again, I want to be clear, you never see Mr. Beller ever again, correct?
Correct.
You talked about this training up in Luther on, I believe it's September 12th. Does that sound about right?
Yes, sir, that's right.
And at that training up in Luther, that's when the plans really start gaining some strength. Would you agree with that? As far as surveillance and things along those lines?
I don't know if I agree with your characterization of gaining strength, but we conducted surveillance that day. Yes, sir.
And training specific to the governor's cottage. Do you recall? If you don't, that's fine.
And no one, I don't think anyone ever informed me that that was supposed to replicate the governor's cottage.
Okay.
So it was the same type of training that I saw in Wisconsin.
That's fair. And Eric Molitor was there, correct?
Correct.
You're familiar with Eric Molitor?
I-
right? Very familiar with Eric Molitor?
No, sir, I'm laughing because I neglected to remember his name this morning.
So, but Eric Molitor was in Adam's group. Is that a fair statement?
Yes, sir, that's my understanding.
And Eric Molitor, based on your observations, was loyal to Adam Fox. Does that sound about right?
I couldn't say, I mean, he was part of Mr. Fox's group.
He's-
There at Mr. Fox's
Right.
invitation, as I understood it.
He was part of Adam Fox's group. He was part of the training with Adam Fox, correct?
I don't recall seeing him do any specific training with Adam.
Other than medical, right?
Correct. Well, he was there he was kind of off to the side as a medic during the kill house drills we did in Luther. The day before, a person by the name of Dan Harris was putting on the medical.
Okay. But you would agree with me that Eric Molitor was Adam Fox's medic, correct?
I don't know if that's it, was the way Adam would characterize it, or Eric would characterize it.
Your Honor, unfortunately, I didn't make a full copy of my transcript because I wasn't sure I was going to be getting into it. May I approach?
Yes, go ahead.
I'm not going to have my own copy to read.
Sir, he was performing a medical function, as I understood it during the kill house. Does that clarify for you?
Well, let me do this. if you read your testimony, September 1st, 2022, if you read that testimony for me, you think that might refresh your recollection of whether or not he was in fact the medic or not?
Sir, I think we're saying the same thing. He was serving as a medic during the kill house portion of the Luther training. That was what his role, as I understood it, was.
So
Whether or not he was Adam's medic, I don't know if I can say that.
Let me rephrase it. He was the medic for this team that Adam had put together, correct?
That I don't know if I would agree with that. He was serving as in a medical function or as a medic during that portion of the training.
Yes.
Page 64, starting at line 6. 65, line 24. I'm not going to have you read it, but if you could, sir,
Sure.
just go through this from here into the next page. Just read through that and then I'll have a couple questions.
You got it. I'm with you, sir.
You with me?
Yes, sir.
So you would agree with me that Eric Molitor had medical expertise, correct?
Mr. Mahler represented that he had some medical expertise. Yes, sir.
And he was part of the surveillance of the governor's house, correct? Or
No,
was
sir.
it surveillance?
Yes, sir.
He was going to be a part of the team, though, correct? That ultimately did what they were going to do.
That I don't know, sir.
But he was present at the trainings you were at, right?
He was present at the Luther training. Yes, sir.
Mr. Beller was not, correct?
He was not at Luther.
You ever see Mr. Beller ever train Mr. Molitor on any medical training whatsoever?
Not that I'm aware of. Yes, sir.
I have no further questions.
Ballard, anything?
Nothing this time, please.
It's in there.
Sir, you communicated with Adam Fox via text message and Facebook message, is that correct?
Just by text message.
Okay, so not Facebook.
Correct.
You were not in any of Adam Fox's wired chats?
No, sir. I was in the Michigan 3% of the wire chat at one point. Yes, sir.
No, Mr. Musical was not in that chat.
I don't believe so. No, sir.
You were not in Adam Fox's Threema Brick Squad chat.
Brick Squad?
Yes.
No, sir.
Okay. You were receiving briefings from the agents during your investigation in this case.
Sure. Yes, sir.
Received information that the group that you refer to as the Wolverine Watchmen has separated.
I think I was told that at one point. Yes, sir.
Okay. You are classifying the individuals that showed up at Cambria and Luther as Wolverine Watchmen.
True.
Those, particularly, well, maybe not Cambria, you may not know, but Luther happened after the breakup of this group, correct?
That I don't know, sir.
You don't know? All right. No further questions, y'all.
Any redirect?
Oh, just one or two questions. Agent, you testified in a different case on September 1st, is that right?
I did.
Okay, it did not involve these three individuals, is that right?
That's correct.
Okay, that was for 5 other individuals in a totally different county.
Okay.
Okay, and so at that time, when you testified, were you attempting to give testimony regarding those 5 individuals? Okay, were you centered on giving testimony about these 3 individuals? Okay, and so Mr. Kirkpatrick asked you a question about the way you testified on September 1st. Can you tell us about that?
Can you rephrase your question?
Absolutely, yep. He asked you about your testimony back on September 1st, being that you didn't remember, or what was your exact words, if you have them?
I said, I don't recall at this time.
Okay, and why do you remember today?
because we prepared for this trial.
Okay, thank you.
Anything?
Prepared for this trial by discussing this case with the prosecutor, correct? Yes. You testified 7 weeks ago under oath and were asked a question regarding who did the medical training, correct?
Correct.
You are an agent of the Federal Bureau of Investigations, correct? You understand the importance of when you testify in court, you review what you did in a case. Is that fair?
To what are you specifically referring
To the training in Wisconsin. You testified regarding the training in Wisconsin at this hearing on September 1st of 2022, correct?
Did I just, yes, I did.
Okay. And you would agree with me, as an FBI agent, you would prepare for your testimony in court. Is that a fair statement?
I prepared for my testimony. Yes, sir.
And at that hearing, you said you did not recall who did the medical training, correct?
That's what I said. Yes, sir.
Prior to you doing this case, I suppose you met with the agents out of Detroit, correct? Or where? Who brought you into this case?
I was asked by the Detroit division of the FBI to participate in.
And they briefed you, right?
They did in a general sense. So often they won't give me every fact that they know as investigators in the case, because I may say something that implicates that I have guilty knowledge. So I may not want to know things like background on these guys because I may say it by accident.
You know who the players are, right?
I know who the players are. Yes, sir.
You don't walk and do an investigation as an undercover and not know who people are, correct?
The subject of the investigation, I would know who those people are.
Made aware before this training, Wisconsin, a part of this investigation involved the Wolverine Watchman, correct?
I was, but my primary focus again was Mr. Fox.
You would have been made aware of who the players were for the Wolverine Watchmen that were going to be in training in July. Is that a fair statement?
I would have been made aware of who the Wolverine Watchmen were.
That's how you testified on September 1st, that you don't recall who did the medical training, correct?
My testimony is my testimony.
I have no further questions.
None, Your Honor.
None, Your Honor.
You may step down. Thank you.
Madam, may I grab my transcript?
Yeah, absolutely.
I don't know what happened.
Disability. Yes.
I need to trace you. State your name, spell your last name for the record.
My name is Sean Toad. Last name is T-O-G-H.
Whenever you're ready, counsel.
Thank you, Judge. Good morning, Mr. Toth. I want to take you back in time, if I could, to the year 2020. Can you tell us what county you were living in back then?
Jackson County, Nebraska.
And were you employed back then?
Yes.
Can you tell the jury where you worked at?
I worked at a gas station, Mug and Bob's, right up I-94.
And where is that from, Munith?
It's the halfway between Grass Lake and Munith. It's where the defendants actually live. It's like 8 minutes.
It's coming from his microphone.
Yeah.
You just gotta sit back, not
Gotta sit back.
Oh. Yeah, okay.
No, it's just when you're that close, it picks up everything.
Is that okay now?
It should be.
Better. Mr. Toad, you were telling us that you worked at the Mug and Bob's, is that correct? And what were your responsibilities there?
I was cashier, stocking, make sure everyone gets gas, greet all the customers, talk to them,
Okay.
get them in, get them out.
How long did you work there?
I started February, mid-February of 2020, to about November of 2020.
Okay, working at, there, did you get regular customers, people that come in frequently?
Oh, yeah.
Okay, do you, see anybody in the courtroom, this morning that you came to know as a regular customer there at Mug and Bob's? Can you point the person or persons out for us, please? Oh, yeah, can we have, we should have people take their masks off.
Yeah.
That's probably a good idea.
There we go. Pete on the left right here.
Okay, anybody else or just those two? Okay, and you're identifying for the record, Your Honor, Mr. Wilson.
It also reflect,
Well, yeah, I'd like the record to reflect that he first pointed at Mr. Bella.
He did, I agree. And then after the masks were taken off, he pointed at Mr. Musico and Mr. Morris. Tell us if you will, they're at the gas station. I mean, what shift did you normally work?
On the weekends, it was mornings. Rest of the nights were midnights.
Did you have conversations with Mr. Musico when he would come into the gas station? Okay, I mean, does Mr. Musico, is that somebody that stands out in your mind, Mr. Tom?
I know only him by their first names.
Okay, well, what first name do you know the gentleman seated with the blue blazer on? And if you can take it, Scott.
Kind of. That's Pete.
Okay, you know him as Pete. Okay, and the gentleman next to him that's wearing a mask, you know his first name?
Joe.
Okay, you didn't know their last names. I'm gonna refer to them as Pete and Joe, okay? Was Pete somebody that you knew to come into the station frequently? Would he come in alone or with other people?
Came in with Joe.
Is that something that was typical? Okay, when they would come in, would you have conversation with them? But can you tell the jury a little bit about what those conversations centered on?
Beginning when I first started to about April 30th, right in that time frame, they just talked about random conspiracy theories, how this COVID situation is taking away their guns.
Did guns appear to be important to them?
They always had them on them visibly, and at least one or two on them at every single time.
Okay, and did they ever talk about COVID and the government at all? Can you tell the jury a little bit about that?
They were very angry that as soon as the lockdown, this was a conspiracy to lose their rights and the rights to own the guns. We're all going to be enslaved in some way. It was very, very off.
Was the governor ever brought up by either Pete or Joe?
Yes, pretty much every single conversation.
Can you tell the jury about that, please?
They were so angry that this lady is taking away, they did this for a reason, to take away the guns, and we have to do something about it. She's a Nazi, she's a tyrant.
Okay, you heard Pete refer to the governor as a tyrant. Is that yes? Okay, how about Joe? Okay, did they ever, did either Pete or Joe talk about what they were going to do?
Yes.
You tell the jury a little bit about that, please.
Especially after April 30th, I'm coming back from the protest, they're really amped up. They always like to say we're a kidnapper. We're mainly start out with kidnapper, scare at first. And then as weeks gone by, they're more and more agitated, where we say kidnap and then up to kill.
And what?
Up to kill and then other things on top of it.
Did they say how they were going to do that?
Not 100%, but basically just have enough manpower to go up there and just take her right by the hand.
Go up where?
Up to where she lives.
Okay, did they say what part of the state that was in?
No,
Okay, in terms of, did they discuss at all any training they were doing?
little bit, they were discussing blowing up a bridge.
Okay, did they say where the bridge was at that was going to be blown up?
No,
Okay,
this was one of the last conversations I had with them before.
now, you mentioned a protest, I think, on April 30th, and I think you said when they came back, they were all wound up or agitated. I'm not sure what your word was, but what protest were you aware of going on April 30th back in 2020?
I really haven't dabbled too much into it, but it was an armed protest at the Capitol in 2020.
Did they talk about that to you? Okay, what did they tell you about it?
This is the first, it's the first time we stood up against the government.
Okay. Did they tell you at all what happened that day when they went to the protest or no? Okay. Did you do anything, how often would you see Pete and Joe together in the gas station? What's kind of, on a weekly basis or a monthly basis, how often would you see them?
It was 1 to 2 times a week.
Okay.
Definitely.
Did they know your first name? Okay. As you got to know them over the months, did their willingness to speak with you increase, decrease, or stay about the same?
A little more increase.
Okay. Did these statements concern you at all, Mr. Toth?
Yeah, it was very, very awkward. And my girlfriend, or my ex, was there each and every time. We had to talk about it right afterwards. Basically, we're like, why we even talk? Why do they even feel it is a need or necessary to want to talk to me in any way, shape, or form, especially saying any of this crap? It was to possibly recruit you, Sean.
Okay. Did you ever take part in any of their, did they have a group you were aware of?
No, I did not take any part of their shenanigans or know any extra activities they're doing besides what they're saying.
Did you ever go to their home?
No, I have a friend that lives like 3 houses down.
Okay.
Driving to his house, I would be going 5.
Are you aware if they were part of any group, Mr. Toth?
Yes, because I sense they're so boastful and wanted to talk so much. And I asked, since I'm a local figure in the town, like, I just moved back. And I want to really know what's going on. Why are these people acting like this? Who are they? So my friend lives down the road and he said, yeah, they're part of a militia
Judge,
group.
you're saying what the friend down the road said.
I would agree, Judge. Yeah, without telling us what your friend down the road said, did Pete or Joe ever tell you if they had a group? Okay, fair enough. Now, did these statements concern you?
Yes.
Did you call the police at all?
No.
How come?
Oh, I basically just didn't want to be involved.
Is this something you enjoy coming to court and testifying about this, Mr. Toth?
Yes, because right after they were arrested, I talked to my recovery community and my ex-sponsor, which is Lawyer Out Recovery Community, which is Chad. And he said,
I would object to hearsay. It doesn't even involve my client, but this is hearsay.
So, are you going for state of mind?
Let me ask another question. If I may. After their arrest, did you contact the police?
yes,
Okay, you tell the jury why you did that.
I felt it necessary to be documented in my experience.
Okay, fair. Thank you, Mr. Toth. These gentlemen may have questions for you.
Any cross?
I have no questions.
Mr. Ballard, anything?
So you had the opportunity to review and speak to the prosecutors before coming here and testifying, is that correct? How is it that you specifically remember April 30th?
Day,
It's what?
it's a big day.
What made it a big date?
Was on, big on the news.
So it's in reflection that you're going back. This isn't from your personal memory that you recall, is that correct?
No, it's personal.
And you just specifically remember it's April 30th. So you recall everything else that was going on in that time frame, correct? Anybody else ever come in, complain about things? Same kind of complaints? Governor, it's shut down. You hear a lot of that during that time frame?
No.
No?
Not like that.
That wasn't my question, sir. My question was, did other people come in and complain about the governor or the government or shutdowns? Come in that time frame, correct? Nothing further. Your Honor.
Anything, Mr. Johnson?
Sir, before you went to work, it was your routine to get high? Before you went to work, it was your routine to get high? You were never high when you spoke to Mr. Musico? You never used drugs before speaking to Mr. Musico? You did use drugs during 2020, correct?
No.
You drank?
I think you missed the recovery thing.
I understand, yeah, but my client, we have other information, but
Okay.
that's his answer.
Anything, redirect?
No, thank you very much, Judge.
Thank you, sir. Appreciate it. You're all set.
Yes. Judge, we're ready to rest at this time.
You ready to proceed?
We
You need a
approach-
minute?
May we approach, Your Honor?
Come on up. Dismiss you for about 20 minutes or so. Got all rise for the jury. Okay. Seated. You're ready.
Thank you, Your Honor. Your Honor, at this point, I'd be making a motion on behalf of Mr. Beller for a directed verdict. The court has heard the testimony in this case. We've gone through the testimony in this case. The testimony is clear in this case. And there's, even in the light most favorable to the prosecution, there's no reasonable juror that, in my opinion, could convict Mr. Beller of materially supporting a terrorist act, gang membership, or felony firearm. And here's why, Your Honor. Regarding the material support of a terrorist act, first of all, it's unequivocal that in this case, the terrorist act alleged is the plot to kidnap the governor. The prosecutor can slice it any way they want. The prosecutor can come in and say, well, Mr. Beller made comments about shooting police officers. Mr. Beller made comments on his QRF at the Home Depot about what he was going to do to police if a police officer showed up. Mr. Beller went to protest where there was conversation, which I submit he wasn't even involved in based on the testimony of Dan. Here's the problem that people have, Your Honor. The testimony of Agent Impola is clear and unequivocal. And that is, on July 27th, when my client said goodbye, he had not been arrested for anything, he had broken no laws, he left the state of Michigan for good. What else is undisputed? At the time that he left, July 27th, there was no plan in place to kidnap the governor. There was no plot in place to kidnap the governor. There was discussions and conversations made regarding that, but again, not by my client. And here's why. Prosecuting attorney tried to present to this jury the Back Shack audio. Your Honor, that is the only facts and evidence that has been presented to this court, period, regarding my client and any conversation he may or may not have had regarding the kidnapping of Governor Whitmer. Well, what did they want to do, Judge? You recall how upset I was. They wanted to present to the jury an exhibit, a little sound bite where my client says, well, and I'm paraphrasing, Judge, I don't have the exhibit in front of me, something along the lines of, well, when we take our governor, domino effect, we take our governor, we want to make sure that all the other states do it at the same date and time. When you read that, sounds like he wants to kidnap the governor. In fact, that's how it reads. In fact, that's what they were going to present to the jury. That's all they were going to present. And then what did I do? I had to argue, fight, tooth and nail. Judge, let's play the first 3 minutes. Play the first 3 minutes. That's all I asked, Judge. They fought me on it. They didn't want to play. And that 3 minutes before that comment, which is the only comment that my client has made regarding Governor Whitmer, period, was, hey, we can get us a conservative judge, a right-wing liberal judge, or a right-wing Republican judge. We can get a constitutionalist or conservative a sheriff. We can get them to do an arrest warrant, a valid arrest warrant. We can use a peace officer to go and arrest the governor. And if anyone does not agree with this warrant, i.e. MSP, then they're on the hook for obstruction. That's what it says. That's what he was talking about. That's the only comment he's ever made about the governor. Other than, if she extends the lockdown, she should be drugged in the streets and hung. Or if she extends this, I'm going to Molotov cocktail her house. There's no facts and evidence that he ever even made a Molotov cocktail. I made that clear. There's no evidence that he ever did anything towards that. Took me how long to get the FBI agent to finally agree that it wasn't a citizen's arrest? It was actually a lawful arrest with a peace officer. Judge, how long did it take for that to happen? It took a minute. I had to work for that. Then, in redirect, Agent Impola, guarding the issue of the governor, what does the people do? Stand up. He wanted to get a boo judge. He wanted to get a boo judge, right? He didn't want to get a circuit judge. He didn't want to get a district judge. He didn't want to get a court of claims judge. He wanted to get a boo judge. What the FBI agent say? Yeah, that's right. That was his testimony. Then I had to yet again get the audio out and say, sir, please show me in this audio where you hear boob judge. Well, there's something in there unintelligible. I can't say for certain if it's boob judge. That happened right here in this courtroom. Again, that is the terrorist act that my client is being charged with of materially supporting. There are no other terrorist acts, Your Honor. There are none. There's talk. There's a lot of talk. They're not Mr. Beller's not charged with making a terrorist threat. He's charged with materially supporting a terrorist act. act in this case is the kidnapping of the governor. Then what do we have? We've got Adam Fox. I think we all can agree Adam Fox is the ringleader here. You can all agree with that. June 14th is the first time that Adam Fox is even brought up with the Wolverine Watchman through a phone call and then a later phone call that night that was put on by Dan, the FBI sitting right next to him. My client wasn't there for the early call to Adam Fox. My client wasn't there for the late call to Adam Fox. My client had nothing to do with Adam Fox. And in fact, the testimony is undisputed that it wasn't my client that brought Adam Fox into this group. Sure.
Thank you.
June 18th. First time my client ever meets Adam Fox. There was some testimony. Oh, there was discussions about bum rushing the Capitol, and Adam Fox was making some comments about this, that, and the other thing. But what did Dan testify to? My client wasn't a part of those conversations. My client did not get involved in those conversations. That's Dan's testimony. It took me a minute, Your Honor, of my million times that I had to go back to the preliminary exam transcript over and over and over again to finally get the correct answer, but I got it. He wasn't a part of those conversations on June 18th. Next, we have June 20th, which I just talked about the shop vac, Your Honor, and my issue there was what was said and what was not said and what was going to be played to this jury. June 28th, Adam Fox, first time he comes to Wolverine Watchman. First time he comes to training. He's listed as a VIP coming to training. Did my client have conversation with Adam Fox from June 20th when he left the shop vac? Oh, that's the other thing. When he leaves the vac shack, it says Adam Fox is crazy. What's the first testimony we get from the FBI agent? Oh, Paul left before Dan. Paul left before Dan. He couldn't have made that statement. He couldn't have said that Adam Fox was crazy. Comes back the next day. Well, I got to fix my testimony. They did leave together, but there's a bunch of pant noise, and I can't really hear what was said. So I guess we got to rely upon what Dan says. But the prosecutor says in her redirect, did Paul ever say that Adam was crazy? Even shook her hands. Crazy. No, he never said that. That's Agent Impala's testimony. On cross, yet again, I had to go back to the transcripts. And in fact, he did. He did say he was crazy on more than one occasion. And then what does the prosecutor, what does Impala say? Oh, he was talking about Leroy Jenkins. And then we're talking about some World of Warcraft game. Are you kidding me? June 28th, they go to training. First training Adam Fox goes to. Paul doesn't invite him. Paul did not invite him. That is undisputed facts and evidence testified to. Adam Fox was listed as a VIP for that day on June 28th. At that training, as the court recalls, there was talk of you're either in this group or you're out. There's talk of 3-plan, Adam Fox talking about kidnapping, things along those lines. This is an ultimatum. You're in, you're out. They tried to testify that that little meeting, that little conversation happened before the training. I get it. They want to show, hey, they're talking about we're going to kidnap, we're going to do this, that, and the other. And Paul didn't leave. He stuck around for the training. Well, guess what? That just wasn't the case. Because when Dan testified, he said, well, I'm not sure if it was before or after the training. So I say, well, if it was after, the prosecutor stands up. Well, you wait a minute, Judge. That's the answer he gave. We don't know if this conversation took place before the training or after. What I say, let's clear that up. And yet again, went back to the exam transcripts and clearly showed that that conversation happened after the training. And that's imperative in this case, Your Honor. Because after this training, my client is gone from the Wolverine Watchman forever. No testimony presented to this court, no evidence presented to this court that he did anything other than leave the Watchman. Then what do we have? Then we have text messages from Dan the informant working for the FBI, to his handler. Doc left the group. This is on the 29th of June. Doc left the group. Get in with Adam. Get in with Adam. Get in with Adam Fox. Good idea. It's unacceptable. Then we have the meeting on July 7th at my client's home where the shadow group, ghost group, QRF, whatever you want to call it, it's been called a million things, where he has now left the Watchman and is now starting his own group. He gives a clear, concise mission statement of this group. The prosecutor tries to flip it around. Oh, he was just talking to one person in the group, just one of them, maybe to appease them. No, he made it unequivocal. Mission statement. We're not going to be the aggressors in this state. We are going to train defensively in case we have to defend ourselves, someone else, or the Constitution. We are not about fucking black bagging politicians. It was said by my client, it was said on July 7th, and it was said unequivocal. What happens after that? Dan, well, Wisconsin, keep an open mind. There's some offensive stuff going on over there. Client goes. What does he do? Goes to training. Testimony is there's a dinner. He doesn't engage in the conversation with Barry Croft. First time he ever met Barry Croft. He never met Barry Croft prior to that date. This is the last time he met Barry Croft. There's no evidence he trained Barry Croft. Dan testified that he didn't even do the medical boot that Paul supposedly put on. That's facts and evidence. Dan testified, I have no idea what happened at that medical training boot because I didn't go through it. That's what he testified to. And then we got Mark that just testified about that training in Wisconsin. And he says, well, Paul was there. Paul was doing the medical training, the tourniquets. Boy, he was the battlefield medical training. I got to go to the transcripts yet again. Because he testified 7 weeks ago that he didn't know who put on the medical treatment or medical training, that it was just some tourniquets and stuff. Then the prosecutor has the audacity to redirect to say, well, that was a different case. That didn't involve Paul. Right? Judge, when you testify in court, you testify truthfully and accurately. When you're asked in court, do you know who put the medical training on? One would suppose, we've all been doing this a long time, one would suppose that the FBI agent, we're not talking about some lay witness here. We're not talking about some citizen or some person that just coming in trying to testify. We were talking about an FBI agent. And it was clear that he, Mark, was made aware of this case and this investigation and the Wolverine Watchman. He knew darn well who Paul Beller was before he ever stepped foot in Wisconsin. Now, all of a sudden, at trial, it's not, I don't recall who did the medical treatment training. It was Paul. Judge, Exhibit 164. Exhibit 164, in my opinion, says it all. And it's just such a when you look at it at first glance, it just kind of doesn't really jump out at you, but it really does. Hey, Exhibit 164 is a message from Paul Beller to Adam Fox. This is the one that, if I may approach, Your Honor,
Come on up.
look at this while I'm discussing it. I don't need to look at it. This is the Facebook message that the people introduced to the jury to show that after Paul left the Wolverine Watchman, he continued his communication with Adam Fox. You know, the beauty of that, Your Honor, first of all, is in this entire case, the prosecuting attorney has made it a point to put a little black box around the things that they find important and they want the jury to hear. And they've done it numerous times. Your Honor, that starts off with, sir, or dear sir, I'm sorry, I don't have it in front of me. The court has it. This is Doc, parentheses, the ex-Wolverine Watchman. He doesn't say buddy, doesn't say pal, friend, comrade, whatever.
Says administrator.
Administrator. But but to him, and he says that he's still down for the cause when he sends this to Adam Fox. Okay, that's what the prosecutor presents to the jury. Then July 13th, which is on the document you have, Your Honor, the transcript or the exhibit. July 13th. This is a day after they leave Cambria, Wisconsin. This is a day after supposedly my client is training Adam Fox and Barry Croft for this terrorist act of kidnapping the governor. The title of that is Dan Abbott. I hope I said that sheriff's name correct. Dan Abbott, Van Buren County Sheriff. And then it says something to the effect of, and the court can read that, here's that sheriff I was telling you about, or here's that sheriff we should reach out to. And Adam Fox says, yes, sir, on it, or something along those lines. He doesn't say, hey, Adam, that training in Wisconsin, awesome. I'm down with you. I'm down with this, what your plan is. He's clueless. And that's Mr. Beller. He's clueless to what is going on here. Because what he's doing is he is relationing back to the June 20th Back Shack meeting where his only discussion about kidnapping anyone isn't even kidnapping at all. It's getting a valid arrest warrant. And that in his mind is what is still going on here. Get a hold of this judge. What do we know after July 13th, Your Honor? He goes to one more training on July 26th. That's in Fowlerville. The PT Cruiser, whether it's offensive, defensive, whatever, I say it's defensive, it doesn't matter. There's no training, there's no prep, there's no conversation, there's no nothing about kidnapping the governor. And on July 27th, I'm out of here. There's no testimony from anyone that he engaged in any training after July 27th, that he went up north after July 27th, that he engaged with Adam Fox. In fact, he rejected Adam Fox. He rejected to swear in for Adam Fox. When Adam Fox wanted him to swear in on June 28th, he rejected that. He rejected that because he thought the guy was nuts. And he knew he was leaving the watch. Then, the prosecutor puts up exhibit I think it's exhibit 177. It's the fuck around, find out chat on July 27th. Prosecuting attorney puts an exhibit up. Again, we have two black boxes and that's it. One is Adam Fox saying, who's down for kidnapping tyrants or something along those lines. The other is a box up in the corner that says Doc, administrator. Administrator to fuck around, find out chat. Why is that important for the people? They got to keep that connection alive between Adam Fox and Mr. Beller. They have to keep the connection alive. They don't do that, they got nothing. That's all they wanted to present to the jury, Your Honor. That's their only exhibit. I had to dig, find the actual thread, go through, you saw me count them out up here, 15 pages. Can you show me anywhere where my client ever posted on here at all? What was his response? No, but well, there's a lot of pages. There's a lot of things to go through. Gee, I don't know. He's on trial, Judge. The final answer, no. No communication. And in fact, the final answer is also, who set it up? Dan, the informant. After he had a personal taco meal and meeting with Adam Fox at the Vac Shack, they agreed, we're going to start up a new one because guess what? You're not in the bonfire chat. So we're going to do this new fuck around, find out chat. Then comes the warning, if you will, of Mr. Beller. I see what they're doing there. Trying to assist in apprehension and detection and whatever. Yet again, sorry, Your Honor, I need to find this. It's exhibit 187. Then yet again, everything we want, we're going to throw a black box on that. We're going to put a black box around what we want the jury to hear and see. That's what we're going to read out loud. This is when Paul says, police were at my house. I'm going to ghost for a while, coming off social media. I don't know who said anything, blah, 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 blah. 3 things wrong with this, Judge. First thing that's wrong with it is the one thing that they don't want to put a black box around. And the fact it took me a minute to get this to be even part of the exhibit. At page 4, when this little chat is concluding, they don't want the jury to hear Doc say, exactly. We haven't done anything illegal or wrong. They're probably just pissed because we're not open to the public like the rest of the cliche militias around. They're just sniffing their noses around, most likely. That's what he says, because, Your Honor, this is August 20th. He's been out of the state now since July 27th. He has not been a part of any training, conversations, phone calls, anything, nothing. He has no idea what is going on back in Michigan. Because guess what? It took me a minute to get here, but when Dan testified, how long did it take me, Your Honor, to get Dan to finally do the transcripts, agree that he selected individuals out of that July 7th meeting at Mr. Beller's house? How many times did I have to ask Dan and go to transcripts? At least 3. At least 3. But he finally acquiesced. He finally agreed. He selected. And Adam got the people that he wanted who were down in the Wisconsin training. Plucked them out of Paul's group. Paul didn't send these individuals to Adam Fox. Dan made that happen. He has no clue. This warning, this exhibit 187, it's not to Adam Fox. It's not to Barry Croft. It's not to Pete Musico. It's not to Joe Morrison. It's to his group that he created on July 7th with a mission statement of being defensive, not offensive, with a mission statement of not being an aggressor, with a mission statement of not black-bagging politicians. That's the group he sent it to. And again, he's clueless of what is going on. Clueless. The last thing I'm going to say is the other thing, part of the prosecutor's argument may be, because my client left the state. I think it's clear. I think the chain of events shows why he left the state. And they may argue, well, he left the state because he was being evicted. And at first, I was like, yeah, he was being evicted. When did he pay his rent? Until Bleeland, the manager, came in and testified. Manager came in and testified about Paul leaving his apartment at the end of July. And she said something that made the light bulb go on. She said he left voluntarily. She didn't say he was evicted. She testified he left voluntarily. Then I got to thinking, that's right. Governor Whitmer did an executive order, a moratorium on evictions. It was a federal law, moratoriums on evictions. He could have hung in to that apartment like a tick, not paid rent, and rode it out, and went on up north with Adam Fox and Barry Croft. They had a good old time trying to kidnap the governor. That didn't happen. Your Honor, I'm ashamed of this case. I'll put it right out there. Been frustrated throughout with the way that this case has unfolded. And I'm going to tell you, Your Honor, I don't find, even in the light most favorable to the prosecuting attorney, that they have provided any evidence to this court that my client materially supported the terrorist act of kidnapping Governor Whitmer. I also do not believe that they have, even in the light most favorable to the prosecution, that any reasonable juror could find my client guilty of membership in a gang. Judge, membership in a gang requires 5 or more in continuous contact. Court already knows, because we're going to be arguing about a jury instruction here in a minute, that we can't look at Harris, Daniel Harris, can't look at Brandon Caserta. We don't get to 5, Judge. With the Watchman, he left. Broke no laws. Started his group on July 7th, he left. The ones that came out of the group, Dan Harris was in there, you're not going to get to 5. This case, Your Honor, should not reach it to a jury as it pertains to Mr. Beller. I do not believe that the prosecuting attorney has met the burden. I don't believe, even in like most favorable prosecution, that any reasonable juror, Your Honor, could convict Mr. Beller of any of these charges. And I'm asking the court for a directed verdict.
Okay, before you give your answer, we're gonna take a break.
Thank you, Judge.
Use the rest. Get back and I'll hear from you. I'm gonna take them one at a time.
Very good.
Thank you, Judge. Speak on behalf of the people. Judge, there's everything that Mr. Kirkpatrick argued, or rather yelled, goes into three categories. One is the issue of fact for the trier of fact, right? So he argued a ton of things about facts and the way he perceived them, and about the credibility of witnesses and the way he perceived the credibility of witnesses. And those are, of course, issues of fact for the trier of fact. The second category of things that he argued were about entrapment, Judge. Entrapment, which is something that we had a hearing about several days where you made a decision. And now he is arguing that Dan pushed his client into this, and that is entrapment. So those two things, which we of course are objecting to his motion for a directed verdict. The third thing, Judge, is a mischaracterization. The third category, I would say, is a mischaracterization of our case theory in this case. The act of terrorism that we are alleging is not simply a plot to kidnap the governor of the state of Michigan. It's rather to kill police officers, kill politicians, and do harm to the governor of the state of Michigan. So that is a misunderstanding of our case theory. As far as Mr. Bellar, the elements, Judge, there are definite questions of fact about the elements that should be for the trier of fact. Material support, you had plenty of testimony that Mr. Bellar provided medical training, and that is material support. Knowing that it would be used in whole or in part to plan or to prepare, Mr. Bellar was part of a meeting for planning or preparation for an act of terrorism. And that act of terrorism, a violent felony, dangerous to human life, intended to intimidate or coerce a unit of government, those were all the things that Mr. Fox talked about at the VAC Shack. So circumstantially, we believe that Mr. Bellar was aware of the Ohio meeting where violence against the government was being discussed. And circumstantially, he certainly knew enough to know what was going on at that meeting. And then afterwards was told explicitly what happened at that meeting by Adam Fox, by Joe Morrison. And so, Judge, we believe that the crime was committed and finished by June 28th. And that's way before he left the state and way before he went out and formed his ghost group, Judge. So in that sense, we believe that a directed verdict motion should not be granted.
Mr. Ballard, do you want to make your motion?
I will, Your Honor. Thank you. Your Honor, I will also make a motion for directed verdict at this time. And basically mine is going to be really, actually pretty quick and short, relatively speaking. Mr. Ralston presented his theory of the case in his opening, of which it was Joe was doing this training. But we heard testimony, absolute and unequivocated testimony, that it was Dan. Again, much like Mr. Kirkpatrick said, it was an extraction process, but he finally said, yes, I was the one doing the training. He did not, Joe was not doing training. They want to say that the terrorist act was the killing of police officers. But I think the court can easily see that that wasn't a terrorist threat. It wasn't a terrorist act. It was a policing of the police. And as things materialized, that's really where it came to be. The act of with the governor, and if they're going to cut this off at the 28th, there was no plan as of the 28th of June. And in fact, all the way further, all the way into August, the testimony is there was no plan that Joe knew of. And the testimony further was that if Joe had known, he would not have condoned it. He would not have approved it. He would not have been down for it. That was the testimony that came from CHS Dan. There was also testimony in regards to the terrorist group, you know, the forming of this gang. But as the court heard repeatedly, the people came, people went, people were discharged, people left. And in the end, the group is questioning, where is Joe? Why is Joe not involved? Joe's being run around by his wife. Joe's balls are in his wife's purse. He doesn't get to go here. He doesn't get to go there. He doesn't get there's nothing gang related, to the point where eventually Joe's reaching out going, there's nothing here but crickets. Nobody's here. I got nothing. So I agree again with Mr. Kirkpatrick. You can't have this continual communication of 5 people, when really at best you've got 2. You've got Pete and Joe, but that's 2. That's not a gang. So all of these elements that they're trying to string together, and I will save some of this for argument if it gets to that point in closing, but I also agree, right? The evidence put up, the exhibits put up were selected to show piecemeal of what this was, not the case in its entirety, right? We don't hear the entire conversations put on, but ultimately Joe was not present for much of what took place. The testimony was Joe was not training. The testimony was that Joe was seeking leadership from Dan to, hey, come into my house. Hey, tell me how to defend this. Tell me how to do this. And Dan provides this. Dan, the paid informant who's selling his information, that was his testimony. And Dan, the paid trainer who gets paid to go out and teach this stuff. And if we're going to go back and even farther say that the threats were against law enforcement, all we have is Dan saying, well, I saw this. We don't have evidence entered into that demonstrates or explicitly shows this is what it is. And I will ask the court to dismiss on that basis.
Response.
Thank you, Judge. Mr. Morrison created this group, Judge, and while he may not have led or taught training, as the testimony said, training is a group exercise. It's squad tactics, right? That's part of the exhibit that we entered where Mr. Morrison was describing what he wanted this group to be. It's team movement that, you heard an exhibit where Mr. Fox was talking about how if we could all train together, we'd be more lethal and more deadly. This is a group exercise. And Mr. Morrison provided his land, his property, which is facilities. And that, Judge, is material support. Facilities or material support. And you heard that Mr. Morrison, when asked if on August 9th, so well into the plot's formation, would he be down with kidnapping high profile assets and making them fall off the face of the earth? And he said, I'd be down for that. I just want to address one thing, Judge, in this is that the 5 or more continuous requirement for the gang element charge, the 5 or more people in continuous contact, that gang has to be in contact with those 5 or more continuous people at the time the crime is committed, not afterwards or for their entire lives. The gang elements require that when you provide material support, you qualify as a member of a gang. And at the time you provided the material support, at least once, if twice actually, on June 28th and August 9th, and knowing that it would be used to plan or prepare for an act of terrorism. Thank you, Judge.
Nothing else.
Okay. Yes.
And I'm sorry, Judge, one more thing. I just want to note for the record as well that Mr. Ballard is arguing entrapment as well. Thank you.
I know it's hard to trap.
Okay. When I look at this matter in a light most favorable to the prosecution, there are a number of issues. The issues will be decided by the jury. the trier's fact in this matter. As noted by prosecution, even though Mr. Bellar leaves the group, there is enough evidence at this point for the jury to make a decision whether or not they were providing material support. And as pointed out, it wasn't just to kidnap the governor. Motions are denied. You've got it, yeah.
Separate issue. It's come to my attention that the record that the court made last Friday as to the excused juror was not, based on the information that I received, the recording was not activated until about the court was approximately halfway through its reasons for doing what it did. I'm going to ask the court to restate that. And I realized this during the hearing when you were speaking that the green light on the camera wasn't on. I think that's the indicator that we're on the record.
Yeah.
On the record, it would not have been on YouTube because Ethan was working on it, but we were on the record when you stated those reasons.
Okay.
Okay. I mean,
She's got a recording of it. It may not have been on YouTube,
and that's the information I got.
and I'm sure
Okay.
it was.
Okay.
But
Very good.
as far as a record being made,
Excellent.
court proceedings, it was made.
Okay. Thank you, Judge.
And bring the jury in.
Judge, can I inquire about time period or number of witnesses at this point that the defense plans to call?
I'm gonna rest. I have no witnesses. I mean, well, you know, I don't have any witnesses.
I have one, Your Honor.
I have one, Your Honor.
Great, thank you.
Go ahead and bring in the jury, Corey.
Your Honor, we addressed this. I'm assuming I will go first in this since Mr. Kirkpatrick will rest. I'm going to call Trooper Tasker, the individual.
Oh, just if I've got to make a quick record before they get in here. Trooper Tasker was sitting in here. I didn't know who he was. He's the gentleman with the big beard. He was sitting in here for part of the testimony.
Yes, Judge.
And I will note, I did not know who he was. I had not met him before.
Anybody got a problem that they want to put on the
Are we
record?
off camera here?
Yes.
Yes, we are.
Okay, good.
Oh, he's not gonna be on camera either.
No, hold on, stop.
You're off camera here, not there though.
Okay, we gotta, so both cameras are running.
Yeah, you can bring them around through there if you want.
No, just hold on for a second. If we keep him back there, he's not gonna get picked up. We're gonna shut the camera down that goes this way. Or shut them both down while he's walking out.
All rise for the jury.
Are they both down?
They're both off.
Okay.
Corey,
Be seated.
this camera needs to be off.
Make sure this camera's not up. Good to go. You have anything on right now? No. Okay. Okay. You swear to tell the truth, the whole truth, nothing but the truth. Yes. You can get the one that gets them, make sure, you can put that one on, make sure this one doesn't come on.
Mine is on.
Good to go. Okay, when we're done. Whenever you're ready, counsel.
Thank you, Your Honor. Sir, good morning. Want to state your name for the record, please, spelling your last.
Detective Trooper Tasker, Tasker.
And how are you employed?
Michigan State Police.
How long have you been there?
6.5 years.
6.5 years. All the standard trainings that go into that, correct? Attended the academy, things along those lines?
Yes.
Okay. I'm going to draw your attention, if I could, please, to July 18th of 2019. You recall that date?
Yes.
Okay. Were you working on that day?
Yes.
What was your capacity on that date? How were you working?
I was working, like road patrol at the Metro North Post.
So you were in uniform at that time,
Yes,
and you are obviously not at this time, correct? You moved on to another assignment?
correct.
Okay. So on that date, you were working marked uniform patrol, is that correct?
Yes.
All right. Did you come in contact with an individual later identified as Joe Morrison?
Yes.
How did you come in contact with him?
It was a car assist, so they were.
Can you tell me what that means?
They were broke down on the ramp from Mound to westbound 696. So I stopped to check on them, see if they needed help changing the tire. And when I talked to the passenger, Mr. Morrison, I noticed he had a pistol on his hip.
Okay. Was it an exposed pistol or was it concealed?
Exposed.
Okay. What took place at this point?
So I inquired if he had a concealed pistol license, CPL. He advised he does not use open carrying.
Okay.
And the law is pretty clear on open carrying in a vehicle, so he's placed on arrest and process. Released shortly later.
Okay. So when you say he was taken into custody, processed and released, about how long is this process? And you can give me a rough estimation. I mean, are we talking about an hour, 6 hours, a day?
It's probably an hour, or maybe less.
Okay.
Because obviously didn't have to wait for a tow truck or anything, and the post is only 10 minutes away, so.
Okay. Mr. Morrison put up any kind of resistance to you?
No physical resistance. Obviously, he was arguing about the arrest and the law and stuff like that, but yeah, no physical resistance.
Would it be fair to say that he tried to negotiate his way out of it?
Yes.
Is that typical with interactions you have with the public, traffic tickets and alike?
I would agree for like traffic tickets, civil infractions, but for felonies, no.
Okay. Did you give Mr. Morrison any advice?
I believe I told Mr. Morrison, to just go to court and, hopefully get pled down to a lesser charge of, CCW.
A lesser charge in CCW, something along the lines of what perhaps?
Improper transport.
Improper transport. So at the time, that's what you would have anticipated coming of this, correct?
Oh, I mean, not guaranteed, but I mean, there's a
Understood.
good chance for him considering his criminal history at the time and those things.
Okay. So you take him, process him, I assume fingerprints, paperwork, stuff like that. Is that correct?
Yes.
Then you let him go?
Yes.
Did you have any other interaction with Mr. Morrison?
No.
Nothing further.
Ross?
Judge. Tasker, how are you doing today?
Good. How are you?
Good, good, thank you. Thanks for coming in and testifying. So you talked about this occurrence on July 18th, 2019 with Mr. Morrison, correct?
Correct.
Okay, and you were working, you said you were in full uniform, right?
Yes.
Okay, and then you went and you went to go assist and you found that Mr. Morrison had a pistol on his hip, is that right?
Yes.
Okay, and during this process, he asked you to not take him in, is that correct?
Yes.
To not arrest him. And in fact, he told you what the law was about carrying a concealed weapon, correct?
Yeah, he tried to explain the law, but, we went back and forth, about open carrying and concealed carrying, and being in a vehicle and outside the vehicle.
Okay, so he tried to explain the law to you, correct?
Yeah, we went back and forth. I did the best I could to explain it to him and,
Yeah.
why he was being arrested.
Right, you explained it to him, right?
Yes.
Okay, but he did not take what you were saying to be the law, is that right?
Right.
Okay, and he was aware when you told him what the law was, that he could be charged with a felony, is that right? And you're aware of the law this in the state of Michigan about people who have felonies cannot possess firearms, correct?
Correct.
Okay, can't have them on your person, right?
Right.
Can't have them in your home, right?
Right.
Can't be around them, not even physically pick them up, but where they're readily accessible to you, you can't have them, correct?
Correct.
If you are a felon in the state of Michigan, correct? And you know, the case wasn't resolved and finally sentenced until November of 2019, correct?
Yeah.
And you said that you would never, you have people who try to negotiate their way out of things when it's something like a traffic ticket, right?
Yes.
But, right?
Normally, no.
Normally, people don't argue with you and tell you what the law is when they are being arrested for a felony, is that right?
Correct.
And in fact, Mr. Morrison, after you booked him in and let him go and he went to court and everything, he called to complain about you, didn't he?
Yes.
And he called your sergeant, didn't he?
Well, the call, I'm guessing the call would go to our dispatch center first,
Mhm.
and then they would, give it to my sergeant from that point.
Okay, so he actually got in touch with your sergeant to complain about the arrest that you made of him, correct?
Yes.
And that was months later, correct?
Yeah, I don't know the exact month, because I transferred to Metro South in September of 2019.
Mhm.
And it was when I was at Metro South.
Metro South, so that means it was after September, correct?
Yes.
And the arrest happened in July of that year, right?
Yes.
And so months later, Mr. Morrison called and yelled about your arresting him, correct?
Objection, Your Honor. There's no testimony that it was a yelling event.
Well, ask him, was he yelling?
Was he yelling at your sergeant about you? Do you know?
I don't know exactly if he was yelling at my sergeant, but I know my sergeant was trying to explain to him the law, and he said the law is very clear on when you can't, open carry and concealed carry. So he was just, telling him the law and things like that.
So he was telling you the law on the stop, correct?
Yeah.
Then he was telling your sergeant the law months later, correct?
Yes.
Okay. And your sergeant told you about that, correct?
Yeah, I asked him about it briefly, and I asked him if it was an incident that I had at Metro North. He said, yeah, it was. And there's pretty much nothing further from that point.
Okay. Months earlier, though, right, the incident?
Yeah, it was months after the incident happened.
Okay. Thank you, Trooper Hesker.
Anything further?
Nothing, Your Honor.
Step down. Any other witnesses?
I have nothing further, Your Honor, at this time.
Any witnesses?
Yes, Your Honor, we made, the defense like to recall, Special Agent Henry Kempler.
Judge, turn the camera back on. Still under oath from previously.
Yes, Your Honor.
Go ahead.
We know your name, sir. You heard the testimony of Sean Toff?
Yes, sir.
He testified that he called the police after he saw this case on the news.
Yes, sir.
After the original arrest, there was a press conference by the U.S. Attorney's Office.
Yeah, I believe it was a joint press conference by all the agencies involved. But yes, I recall a press conference the following day.
They talked about the details of the case.
I believe they just talked about the general nature of the charges, and they didn't provide very much specific details, but certainly the fact that, the governor was the target was mentioned.
Did you watch the actual press conference before his testimony?
Did I watch it?
Yep.
I have, I believe I saw a portion of the press conference that day on the 8th, but I haven't seen it since then, since October 8th.
And there's been 2 trials regarding this, these accusations, correct?
Judge,
Federal court.
I'm gonna object here. I think the court's issued its orders regarding that.
Yep.
What's the objection?
Should I mind you get
I'm not getting into the results of this trial.
Okay.
There's been news coverage of 2 trials regarding this case.
There's been news coverage of multiple trials, multiple preliminary hearings, motion hearings. There's been news coverage of many cases, not involving this one, but involving the entire investigation.
No further question.
Anyway,
Just maybe 1 second. But just one question. To your knowledge, as the OIC of this investigation, did Sean Toth come forward just recently after all of this news coverage or around the time?
To my knowledge, Sean Toth came forward immediately after hearing word that there was a plot against the governor.
Okay, thank you. That's all.
anything further from
I
anyone?
have no question.
And the word he got was from a news conference.
I can't testify about where he got his word. When I heard him here today, he said he follows the news. But whether it was about that conference, whether it was, something that popped up on Facebook, I don't know. But I believe it's fair to say that it was news related.
Yeah, thank you. No further questions.
You can step down. Anything further from anyone?
On behalf of Mr. Beller, the defense rests.
Yes?
On behalf of Mr. Morrison, defense rests.
Yeah, Mr. Musical, defense rests.
Counsel, you're even a little bit faster. I heard we'd be till 1:30 or 2 o'clock today. I will tell you, I'm gonna release you for the day. We thought we were guesstimating how long the testimony would be, but we were trying to get all the closing arguments into one day so that you're not hearing, say, just the prosecution and one other person and we run, because the closings are gonna be very lengthy. And we'll start them up. Everybody be ready Monday?
I'll be ready, Your Honor.
Judge, and we'll just say we're resting no rebuttal witnesses, Judge.
Okay. Yeah, I am correct. Everybody anticipates, from what I've heard so far, that we're gonna have very lengthy closings.
Mine will probably be 45 minutes to an hour, tops. Well, you know what, Judge? I don't know where,
I think we'll
I
finish
will
them
get
in
as quickly as I can.
we'll definitely finish them in a day, Judge, and I don't think it'll take the whole day.
Okay.
Yeah.
Well, hopefully you'll be deliberating on Monday. We'll see everybody back here Monday.
All right, Jerry.
Okay. See everybody Monday.
Oh, we're gonna argue.
Judge,
We got issues with some jury instructions.
Oh, I haven't gotten any proposed jury instructions.
I just printed them this morning since I wasn't here when I got them.
Maybe I didn't
Oh.
get anything. from you.
Going off yours, but,
Oh, okay. I
I'm
thought
gonna
you were
fix
gonna
them.
prepare something special and
I did. Oh, yes, I did.
I never got.
Yeah, I got it right here.
Is there any, have any,
Yes, they're all standard. I emailed it.
I received this morning, but I didn't look up the exact instructions, but I could do that. No, no.
yes, I.
Should be,
Okay, sounds good.
all the 8 should be aiding and abetting.
Aiding and abetting.
Yes.
Okay. And I'm sorry, the one you sent. Excuse me. The one you sent just had numbers. Do you have a copy of that at all?
The additional instructions.
The ones that Mr. Johnson filed. He just gave me a bunch of numbers. I didn't have the actual instruction or how you wanted it filled out. Do you have any of that?
No.
I didn't mean to interrupt. Go ahead.
And Judge, I emailed all my instructions to the court a couple days ago.
Motion. In brief in support of special jury instruction on entrapment.
Nope, I never got anything.
Who'd you email them to?
What's that?
Where'd you email them to?
To Betsy and to the attorneys
When did you?
and to Miss Bollinger, I think.
I got it.
I got it last Thursday or something like that. I got it.
You don't have anything.
I can resend it right now.
Oh, I've
Judge.
got it. If it's this one right here, I've got it.
Oh, you've got it. Okay, you got a whole packet?
That's the special.
No, that's the special. Okay, I sent an entire packet. I can resend it, Judge.
I have
Well,
a
I've
hard
got-
copy of Ms. Dottamani's package.
Oh,
if the
great.
court want. I have it right here in its entirety.
Awesome. You can,
You want to see it before I give it to them?
no, no, I trust that you. Fine.
And here's the-
Yeah, no problem.
There's
Maybe I
the-
can ask Betsy. if
There's
she
the
can make
tracking
it.
one that's added.
Yeah,
and
great.
there's
The verdict one.
Yep, it's all right there.
But I'm sorry, it's a full packet. It's got the verdict forms, the requests for our special instruction.
I'm making a copy of that. I'm sorry. Thank you.
It's two-sided. I'm sorry.
Yeah, that's my fault.
You don't wanna
That's
get yelled
just-
at?
I don't want to
Printer.
get yelled at.
You know, we're local county government, right? We're trying to save money.
How many copies do you
Design.
need?
Because I'm all about being E-friendly, Your Honor.
Am I just making one copy?
Yes, for the judge. Thank you.
I didn't get anybody, somebody else send something in, because all I've got so far is the prosecutions. Johnson's
You're gonna have approach.
specific request, but not the. I'm gonna go with everything they've got, except for when we get down to some of the other ones.
And
So I asked you all for complete packets of what you wanted. And the only person that complied with that request is the prosecutor.
That's why I brought that pack, because I'm going with their pack. I'm good with that. That's,
Okay,
and that's what I had.
that's
for-
what I'm saying. I'm gonna be
Yep.
going with that, except as we get through any specials.
And Your Honor, I'm in agreement with their packet too. The only issue I have is I want the actual for the elements, they've got terrorist acts providing material support. I want the actual jury instruction 38.3A providing material support for an act of terrorism. And regarding the gang motivated crime, the gang membership felony, I want the actual jury instruction 10.10 gang motivated crimes.
Do you have those for me?
I'm sorry?
Have them for me?
Yes, I do, Your Honor. Obviously, I will have to put in the information exactly how they put it, but that's the one I want. And I apologize to the court. I haven't been able to be at the office. I'm not trying to use COVID as an excuse, but I don't have a problem with any of their other ones, just I think the actual jury instruction, because what they've done, if the court would look at, for example, their
Let's
proposed.
do this in some kind of order. Everybody can sit down for a second. Far as their instructions, you're all in agreement, correct? That's what you've all stated.
I'm in agreement with all of them, with the exception that the gang membership felonies and the terrorist acts providing material support, I'm asking that the actual jury instruction be used, because what's happened is when you look, Your Honor, at, for instance, jury instruction 2.41 elements of the charge, gang membership felonies. If you look at, what's that?
Gang motivated crimes.
Right, but if you look at their instruction, 2.4, and they have classified it gang membership felonies. All I'm asking is that we use 10.10 and then fill in the information, which I'm happy to do this afternoon, including these witnesses or these defendants.
I would,
Instead of their.
It's one of their first ones, Your Honor.
Elements of the charge, terrorist acts, providing material support. Elements of charge of gang membership felonies.
Yes, Your Honor. When you look how they've classified this, it says gang membership felonies. That's not how the real court rule or the jury instruction says. And I don't have it in front of me now, Your Honor. You have my copy, but it says motivated gang crime.
Gang motivated crimes.
Yes, that's how it should be titled the same as it is when there's a actual instruction on point, we should be using that instruction. So,
Response.
Judge, the instruction itself is completely the same, and I just filled in the things that are supposed to be filled in. I entitled it Elements of the Charge Gang Membership Felonies because that's how it appears on the information and on the verdict forms. And so I just retitled it to give it a title so that the jury understands which charge they're looking at. And the jury instructions, Judge, are standard, but they are able to be edited because of this reason, so we can make clarity for the jury. And so that's what I'm proposing here by changing the title slightly, is clarity for the jury. But the content is exactly the same.
in Your Honor, I would ask that the title of the jury instruction be what the jury instruction is. 1010, they want to put gang membership felonies. It actually is gang motivated crime. And that's what I think it should be titled. That's my issue with that particular instruction. And more importantly, once we're done with this one, Your Honor, the same issue is going to be with, I'm sorry?
Is it dealing with this issue? I'm not going to do a 5.
No, I understand, Your Honor. And so with this one, all I'm asking is that how it's titled, it should be titled
I get it.
gang motivated instead of gang membership felonies.
I don't have the charging information, and it's, what does it specifically say in the charge?
I can pull it up, Judge, and tell you right now. I'm reading from the final informations. Pulling it up. Count 1, gang membership felonies. Being an associate or member of a gang to commit or attempt to commit the felony of providing material support for acts of terrorism, and his or her association or membership with the gang provided the motive, means, or opportunity for committing the crime.
Well, they've heard 2 weeks of testimony. I'm going to use the prosecution's heading on it. That's the way it is in the information.
And then, Your Honor, I'm sorry.
Next one.
The other one is the terrorist, the title, the heading of how the prosecutor has prepared the instruction, and it's 2.1 elements of the charge dash terrorist acts dash providing material support. I would ask that that be titled as it's written in the jury instruction, and that is, I don't have it in front of me, Your Honor, but I believe it says providing material support for a terrorist act, not terrorist acts dash providing material support. So I would ask that it be titled as it is in the jury instruction in the standard jury instruction, Your Honor.
So I'm sorry, I just so I'm clear, you want providing material support for an act of terrorism?
I'm sorry, Your Honor, could I have that jury instruction back?
Yep.
You got it? It's 38.3A. So I would just ask that it be titled providing material support for an act of terrorism.
I don't care, Judge, if he wants me to change that, I could.
And-
That on
Yep.
the jury instruction if you'd like, but then I would ask that any change would be reflected on the verdict form to be the same.
Correct.
Agree.
And then,
That change.
all right. And then lastly, Your Honor, we had had numerous discussions regarding the acquittals coming in, not coming in. The last thing the court asked me to do was try to come up with some kind of an instruction that we could argue to see if, because I do believe it's definitely relevant for the gang membership portion of this, because you've got to have 5. And I provided the court with a proposed instruction. And I just gave it, in all fairness, I just gave it to the prosecutor because I just was able to do it this morning in the office. But do you have it, Your Honor? That might be. And I only related this to the gang, the motivated crime, not to the materially supporting.
Response?
Yeah, Judge, this, I mean, the problem I have with this, and I am objecting to this instruction, is that this is not the state of the law. This is just simply not the state of the law, in that they can't take into account other people to use those people to total up to 5. And again, it's not that it has to be, the law does not reflect that it has to be 5 people all charging towards that same crime. It just says 5 or more people to make a gang. That's a different element. The first element of this is that a gang is considered this. And this is, we're saying, what fits the definition of the Wolverine Watchman. And then the person, the second element is that the defendant was a member of that gang. Okay. The third element is that, you know, they committed this other crime while they were a member of the gang. It does nothing to do with 5 people. And then the fourth element, Judge, is that, you know, the gang provided the motive, means, or opportunity to commit the crime at that time. So this is just not the state of the law.
Your Honor,
And this court, when it is giving jury instructions to the jury, this is an argument. This is not law. You know, this is just not the state of the law.
Your Honor, the third paragraph down, second paragraph,
which one?
sentence, I'm sorry, on the one they proposed under gang membership felonies. Elements of the charge dash gang membership felonies.
Yep.
The third paragraph down says, to prove that the group of persons was a gang, the prosecutor must prove that it was a group of 5 or more persons who had a continuing relationship with each other and identified themselves in all 3 of the following ways. That's the 5. When you go down to the very last paragraph, Your Honor, it starts with fourth. Fourth, that the defendant's membership in or association with the gang provided the defendant with the motive, means, and opportunity to commit the crime of terrorist act providing material support. Again, my argument has been throughout that the terrorist act is the plot to kidnap the governor. These 2 were found not guilty of conspiring to kidnap the governor, Dan Harris and Brandon Concerta. I don't want to beat this dead horse because this court's heard this argument, I'm sure, ad nauseum. But when I had the last hearing, you know, it was relevant for the prosecutor at the exam to say, hey, Judge Claren, these persons were charged federally with conspiracy to kidnap the governor. It's absolutely relevant because without the conspiracy to kidnap the governor, what are we materially supporting here? I mean, because there's no other crimes, Judge, they're not going to be able to show this jury any other crime that my client did other than this connection to this alleged plot to kidnap the governor. And so they show videos of Dan Harris, Beaker, and Brandon Concerta, Tats / Wayward, and attribute that to my client doing this training and doing all this stuff as a gang when they should not be included, because in order for there to be a conviction for a gang motivated crime, you got to have a gang motivated crime. And they went to trial on conspiracy to kidnap the governor, which is the very crux of this case as well, and they were found not guilty. So now we're going to somehow lump them back into Mr. Beller and attach them to Mr. Beller to be the 5 necessary for this material support of a terrorist act when they were found not guilty of the very act that my client is accused of materially supporting. And I think the jury, we couldn't get in the acquittals, but now, and again, as I argued before, they put facts and evidence with Dan Harris and Brandon Concerta. They showed the videos in Wisconsin with those individuals involved in that training. They played how many audios and how many text messages and how many threads with Beaker, Dan Harris, or Brandon Concerta or Tats, the 2 guys, repeatedly. And again, I couldn't stop that from happening because the court already made a ruling that statements of co-conspirators were coming in. So now they're getting the co-conspirator statements to the jury, Dan Harris and Brandon Concerta. The jury can't hear that they were found not guilty of conspiring to kidnap the governor. And now they want to use these individuals to now and get to the number they need for the gang. That's why the court asked me to fashion something. I think it's appropriate. And if they want me to change something, I will. In all honesty, I started working on this last night and I did it this morning. I don't have a problem if they want some changes, but there needs to be something presented to the jury that these two individuals should not be taken into account when it comes to the gang charge.
Judge, Mr. Kirkpatrick misunderstands our case theory here. It is not just about one act. It's not just about one plot to kidnap the governor.
Where's the other
This
one?
is about killing police officers, killing politicians, and supporting a plot to kidnap the governor. The support, Judge, is provided to Adam Fox and Barry Croft. And this fourth element, Judge, is that the gang provided the motive, means, or opportunity, right? If Mr. Bellar hadn't been running a gang with Mr. Morrison, then Adam Fox never would have connected with them. Barry Croft never would have connected with them. They never would have sought out the training that was being provided at Mr. Morrison and Music Goes Home. This is different. This jury instruction is not the law. And what occurred in a federal proceeding, as we've said this entire time, over many, many motions and many, many asks for reconsideration of your already done ruling, is that, you've already made your ruling, Judge, on whether a different trial with different charges, with different people comes into this trial. And what I'm saying, Judge, is that this does not reflect the state of the law regarding gang membership felonies and is not based in any statute or case law that even exists on the books.
And Your Honor, what happens in federal court shouldn't have any bearing, yet they presented that to Judge Claren, and they used that in their argument to bind my client over to circuit court on materially supporting a terrorist act. Now, all of a sudden, what happens in federal court doesn't matter, but at the exam, it mattered to them.
Is that correct?
Judge, I don't think that we did that. I mean, I don't have the preliminary exam in front of me right now. And what happened in preliminary exam really has nothing to do with the trial we just presented and rested on.
We had an argument, Your
Judge,
Honor. We had an argument before you. She's now telling the
They're going to
court.
be more and more yelling now.
She's now telling the court
Your
that
Honor,
she didn't say this.
I can speak to that, Your Honor. And we get the transcripts. At examination, Agent Impler was asked who Brandon Caserta and Daniel Harris was. He said that they were federally charged defendants in this case. I objected, said that was not relevant.
That happened.
Yeah.
That happened. I agree with you on that. Okay. But did the judge base his opinion? No, he didn't. Or his bind over decision at all on the fact that they were federally charged? He did not, Judge. There were 40 members, at some point, 100 members of the Wolverine Watchmen. We have exhibit number, I believe it's exhibit number 9. We had a board with multiple people on there. That is what we were saying, Judge, is that has to do with 5 or more continuous. That's a different element. This is not based in law.
And Your Honor, I did read those transcripts to the court already. I read those transcripts to the court in this trial on the record. And I did read specifically Statamati making it clear over objection by Mr. Johnson of the fact that I believe it was Dan Harris, was charged federally. And there was an objection. And it is relevant, Judge, because we're here for materially supporting this conspiracy. I've got the they're already in the record. Your
Which,
Honor.
by the way, he did not base any of his bind over decision on the fact
How do you
that
know
they were
this?
charged, because he didn't say it. It's not part of the record. How do you know this?
I don't. I'm not addressing the court and saying that I do know it.
It is not in the record that he based any part of his decision on the fact that one question was asked about who are these people, and Agent Impler provided an answer: federally charged defendants. It was like a one line in the transcript.
That had to be argued, and you said it was very relevant and necessary. So it's not like it was one line.
The
It was
fact that they were
argument.
federally charged has not come in this trial whatsoever. Not a single fact and evidence has anything to do with the fact that they were federally charged. He just wants to jump up and scream.
No, actually, you're right. It hasn't, because it hasn't been brought in over my objections. I've objected repeatedly. You bring,
Congratulations.
thank you. You,
Yes, sir.
Sorry.
you brought in Dan Harris and Brandon Concerta repeatedly. You have brought in, they're talking about getting bombs and the tax and all this stuff that they've done. And yet this jury doesn't get any inclination whatsoever that the two of them were found not guilty of conspiring to kidnap the governor.
Being federally charged never came up in this trial once.
Because we weren't
Not a
allowed.
Single time, which is why it's not relevant
We-
now to give this instruction.
The
And
court-
again, 403 judge about confusing the jury and misleading the jury.
And the court,
They
after,
still want to get up and argue to the court and argue to the jury because those guys weren't, yeah, again, it's the same ruling that this court has already made like 14 times already.
John, you asked me to do this.
I ask you for more information on this point. Well, the jury has not heard about the federal case. Come in who was not guilty in the federal case. I'm not gonna give him this instruction. Next argument.
Your Honor, I'm sorry, I didn't mean to interrupt the court.
No,
Could
go.
we make that part of the court file just so
Yes.
if there's ever an issue
Let's
regarding?
mark him as an exhibit.
It would be I think it'd be DDD. CCC.
Yeah, preserves it for appeal.
Thank you, Your Honor.
And then Mr. Ralston will address. Oh, I'm sorry.
Yeah.
Okay. Next.
Mr. Ralston will argue, Judge, we filed a motion regarding a special instruction. We're seeking.
Which one is it?
Go ahead, I'm.
Which one is it?
This is our motion for.
No, I mean, do you already have the
Yes, it's included.
proposed instruction?
Yeah,
It's like
this is
page
the
four.
document I delivered to Ben Sherman.
Oh, the brief and. No, I didn't see it until a few minutes
Does the
ago.
court want to, I know we're gonna argue Monday morning,
Well, when they come in, I want to be ready to go. We're gonna take a short break. This is about 8 pages and it's got law.
no problem.
Want a chance to read it over. Try and do it. a second.
Sorry, he's coming.
Just a second.
Judge, we filed a motion seeking a special jury instruction as to the
Right.
judgment. Just a couple of quick points. The role of the court is clearly present the case to the jury and instructed on applicable law. That's People versus Kovac, 274 in the shaft, 58,007 case. And also citing the court rule 2.512 D4, that the model jury instructions, it may also be necessary to provide additional instructions on applicable law not covered by the model jury instructions. And I kind of start with those 2 points that, it's not an unheard of thing. Instruction is needed given a particular set of facts or circumstances. As this court's well aware, you conducted an evidentiary hearing back in February this year, held that entrapment was not proven by preponderance of the evidence, that as a matter of law, ruled that entrapment did not occur. Get to the policy of why we have entrapment. It's to prevent or prohibit governmental overreaching. It's the policy behind it. In Michigan, we have it bifurcated through question of law for the court. As I indicated last week that I'd be filing a motion asking for a special on this. I told the court, and I think everybody would be on the record time, that there's a little bit of leakage, if you will, or seepage that occurs in entrapment cases that gets to the jury. But the thrust of our ask today for this jury instruction is, and really what's happened is it's become a core theme really for the defense. And you certainly heard that today from Mr. Bellar's counsel. And that's one of his primary thrusts to the jury. And be that as it may, we should endeavor to follow the law. And in this situation, it's common that I found that doing this for the length of time I have, it's rare that we walk a bridge that hasn't been walked before. And that's People versus Patrick, and that's at 170 in the shaft, 152. That's a case that's on all fours factually and legally. To this one, and the first summary of that, I'm sure the court's had a chance to read it, is Judge Talbot was trying a case, jury trial. Judge Talbot appeals. He, during the course of the trial, evidence was elicited that can only be, looked at in terms of the reason it was elicited was because of entrapment. And what that does is, and that invites jury nullification and also invites confusion on behalf of the jury under 403. So kind of going back to, again, the obligation of the court to provide clear and concise instructions as to the facts and the law of the case, that being your role, we asked for this instruction, which actually, this was affirmed in a per curiam opinion by Judge Kelly, Judge Burns, and Judge Gillis. And the instruction that Judge Talbot gave to the jury in that instance was warranted. And, the opinion, speaks to this very clearly. And, I'll quote here. Page 161. This is a short case, but it's just spot on. We agree at the trial court that such an instruction may be given, referring to the one that we've offered the court today, when the defendant attempts to re-argue the issue with the jury and the prosecutor's objections to the relevancy of certain testimony, as well as the trial court's order sustaining these objections, make it appear that something is being kept from the jury. The trial court could have further instructed the jury that the entrapment did not involve an assessment of the defendant's guilt or innocence. The instruction that we have provided to the court today takes into account that concern that the Court of Appeals had, although finding harmless error for the lack of it in the case that People versus Patrick. In this case, Judge, this is an appropriate instruction to give. The defendants had their moment at the entrapment hearing. They have, throughout the trial, installed evidence that goes to the entrapment defense. And with that in mind, we'd ask the court to give this instruction to the jury under the case law of People versus Patrick. Court have any questions for me?
Your Honor, I'd ask the court to deny the request for this instruction for several reasons why. First of all, the case they decided, there was no objections in this case. No arguments between the prosecutor and the defense in this case regarding entrapment. Entrapment is not even, the word entrapment, much like their argument for the acquittals in the federal case was not talked about during this trial. The federal this, the federal that. Same thing with entrapment. Entrapment has not been mentioned one time in this case, Your Honor, not once. It wasn't mentioned in an opening. It hasn't been mentioned in direct. It hasn't been mentioned in cross. It will not be mentioned in my closing. And here's the thing, I'm not arguing entrapment. First of all, entrapment presupposes that you broke the law. My client didn't break the law. That's number one. Number two, the reason why the things that I brought up in this trial were not for entrapment, it was intent, state of mind. In this case, Your Honor, the people have to prove beyond a reasonable doubt that Mr. Beller knowingly materially supported a terrorist act. So when I bring in issues such as Dan reaching out to his handler about should I get him with Adam, I'm not trying to show that as entrapment. I'm trying to show that as what is Mr. Beller's intent. His intent is not to get this group of people that he just met with Adam Fox. His intent is to have his group, his mission statement be defensive. His intent is not for these people to later on be removed from his group and given to Adam Fox. His intent is we're going to train to be defensive. So I have not one time insinuated entrapment, spoke of entrapment. The fact that the people don't like the fact that some things happened in this case that I think may have furthered some things along, it's not for purposes of entrapment. It's for purposes of intent. Intent on my client. What's his mindset? Is this what his knowing was, or Is this something that was occurring outside of his control he didn't know about? That's not entrapment. Secondly, the jury hasn't even heard the word entrapment. Now, much like the defenses are the people's argument ad nauseum when I'm responding to my wanting the acquittals in, responding to when I want the jury to be made aware that these two individuals were found not guilty of conspiring to kidnap the governor. Their argument is it's going to confuse the jury. It's part of it. Federal court's different, from state court. We didn't talk about federal court. The jurors didn't hear anything about federal court throughout this whole trial. And now all of a sudden, we're going to throw at them that Dan Harris and Brandon Concerta can't be brought up or they can't use them as two to come to the five. I get it. The court's made a ruling, Your Honor. I respect that ruling. The same applies to the people. Not only do they want this court to read an instruction about entrapment, which they've not even heard yet. They've not even heard that term yet. They go so far as to talk about the court's rulings, and we had hearings, and the court made this ruling, and insofar as, and again, and let's see. In other words, it's for the judge, not the jury, to decide. Prior to this trial, the court took testimony on this theory and subsequently ruled that there was no entrapment by the government and its agents. I've not argued entrapment once, nor do I intend to. If entrapment comes out of my mouth, then by all means, this is something that may be necessary for the jury. But they are to weigh the evidence. They are to weigh, and Your Honor, I think they are going to take some issue with some of the actions by Dan in this case. I think they are going to take some issue by some of the communications between Dan and the FBI, and they should. And they should weigh that. And they should weigh that with what was my client's intent when he was training, not whether they entrapped him. I don't even see where the entrapment is at this point. Now that this trial's over, Your Honor, I don't even see where the entrapment would be. I just don't. Where's the entrapment? He leaves, they decide to take some people out of his group. They take, it's like taking gasoline to a fire and throwing it on. They throw people in with Adam Fox that he trained with, that he started his QRF with. Your Honor, this jury instruction is confusing. It's not relevant to the facts that were presented in this case. Entrapment has not been said once in this case, and now this jury is going to be confused as to why are we getting this jury instruction on entrapment, and why are we being told that the court had hearings outside of the presence of the jury, and why are we being told all these things and it's a matter of law, and what does this mean, guys? That is the definition of confusing the jury. And Your Honor, I would ask that you deny. Quite frankly, I think it would be a reversible error if the court allowed for this instruction to go forward the way that it's written. And I'm certainly not trying to discredit the court on whatever way the court goes with this ruling.
Mr. Kirkpatrick, I assume a lot of my sentencings and everything else goes up. And if the Court of Appeals disagrees with me, I'll take a look at it and try and follow what they tell me. More often than not, fortunately, they agree with me.
That is correct, Judge. I agree with you on that for sure.
I mean, you know well that we've made new law and 30-year precedent. So.
Absolutely. So this is confusing. Entrapment has not been raised, not once. Entrapment, I have not raised entrapment from the beginning, not one time. I've not used the word entrapment. I've not said the word entrapment. I have not said anything other than the truth and the facts and evidence of how this case played out and how some individuals that were trained by Mr. Beller made it to Adam Fox. That's it. And the jury's entitled to hear that. That does not make entrapment. That explains intent. Did he knowingly do this? Or unbeknownst to him, this happened behind his back? That's the issue, not entrapment. I'm asking the court to deny the request for this instruction.
Do you want to respond to each argument as we go, or?
Sure, Judge. You know, we sat through the same trial we all did, Judge, and To be frank, I mean, it's disingenuous to say that he's not arguing entrapment. He's not using the word, of course not. I understand that. And if he did, you know, it would receive the court's review very quickly, I think. But, you know, when you're putting in messages from Special Agent Chambers to Dan that do not get to the defendant's ear, I mean, what you're trying to show there is conduct by the government that is unsavory in the eyes of Mr. Kirkpatrick. And the point that I try to make here is his strenuous argument that he isn't arguing entrapment does not fit with the questioning that's gone during the course of this trial by him. And if the requirement was that you have to speak the word entrapment, well, then I guess People versus Patrick would probably read it. I mean, but you know, that case, and I beg the court to review it, is spot on. It's what's fair in this particular instance, given the questioning of the witnesses, the entrapment-like arguments that are being made. And, you know, the fairness issue really lands with, number one, why are we doing it? Well, because of the questions asked. And number two, because of the state of law in Michigan that, you know, entrapment is a legal defense, not a factual one for the jury. And, you know, I'll conclude with this thought, you know, in terms of that jury instruction being confusing, I beg to differ. The Court of Appeals and the trial court judge did not find it confusing in any way. And if you're not arguing entrapment, then I guess it leads me to the question, then why is this an instruction which is unneeded, kind of given the questions that were asked during the course of the trial? Court, have any questions?
Can I just say one thing and then I'll be done?
You know, this is where I know. Go ahead.
Don't tell me how to run my court.
I understand, Judge.
Your Honor, he just made my argument. He says Mr. Kirkpatrick gets in texts that his client doesn't even know about. That's what he just said. And that is correct. A client did know about those texts. It goes to intent. Had no idea what was going on behind the scenes here. Had nothing to do with entrapment. It had everything to do with what did my client know, what was going on around here, and what was my client's intent when he was doing certain things. That's it. And as far as them bringing up this case, this jury instruction that was brought up for that case is not this case. So I'm asking the court deny the request, Your Honor. I don't think it's appropriate, and I'd ask the court not allow it.
Mr. Ballard.
Thank you, Your Honor. And I'll be brief on this. My issue is I've not questioned on entrapment. I've not pushed it. I know Ms. Dottamani said earlier that, you know, my argument in regards to motion was entrapment. But and as I seek through that, I think, you know, I don't know how my argument in there was meant to further an entrapment. I do think this is confusing. I think this raises a question for the jury that is likely not in their mind at this point. And I think to say to them, hey, don't consider this, if it's not in their mindset, why do we give them this to make them go, well, is that what this means or that's what this means? Some of the questions, yeah, if this was an entrapment case, could have gone that way, but they can also go to credibility. As Mr. Kirkpatrick said, they can also go to intent. You know, when we're questioning, for example, Dan, my questioning as to who did the training is not meant to entrap. My questioning is, you said Joe was doing the training, but that was not your testimony previously. So this is a credibility issue. This is a do you remember issue. This has nothing to do with entrapment. So I would ask, simply because none of that has been argued. I agree with Mr. Kirkpatrick's argument that it's not been posed that way. You can easily look, again, on both sides of the aisle and go, well, for one side it's entrapment, for one side it's credibility. But to include this only serves to add an element to the jury that I don't believe that they've currently been presented with.
Response? So I'm doing one at a time so that you're not trying to lump everybody together.
No problem. Does the court have any questions for me? Okay, thank you.
Mr. Johnson, any argument?
And I do agree, the court has the duty of determining what issues arose in this trial and what jury instructions should be given. I think that as co-counsel stated, there's a difference between arguing who was leading the training for purposes of combating whether there was material support of terrorism because you provided training versus making the argument that a confidential source led the training, therefore this is a trap. And I think what runs the risk, and maybe the court has to take this under advisement until they hear the closing arguments. I think that's why most judges give the instructions after the closing arguments and then evaluate how the facts were argued. Because I think my concern is that, and I don't want to speak for counsels, that the counsel may say, you know, material support of terrorism here on the jury instruction says, did you provide training? And they're going to argue about who actually provided the training. If the court then comes and gives that instruction as it's read, I do believe it can confuse the jury as to whether or not they can consider whether or not if Dan provided the training, are these guys not guilty versus, oh, they're saying Dan argued the training, so everybody's in trap. And I do agree that when you have these type of issues, these things do bleed over. Now, I guess the issue is, has the road been flooded with questioning regarding entrapment? Or is it just a little water on the road that is just going to be expected in these type of cases, John? And at this point, I think we just have a little water on the road.
Any response to that?
Just as far as the confusion issue, again, I think the Court of Appeals didn't find it in Patrick confusing at all. That's the only point I'd make, Judge.
I'm going to stand on my argument up to this point, Your Honor.
Well, the jury in this case has paid very close attention. Many of them are taking notes throughout the whole trial, majority of them. There have been various questioning that has gone on that suggests that one of the defendants or all of the defendants not have taken the actions that they took. Was it not for Dan's involvement? My concern is as Mr. Johnson puts out, just not a bad idea of waiting and deciding on this until after the arguments have been made. My problem there is that they've already heard testimony that would suggest that the way the questions were worded suggests that they would not have taken these actions or had they not been motivated to do so by Dan. For those reasons, I will include this as a jury instruction, subject to, if you have modifications to it that you think clarify things. I think it, Mr. Palace write this?
Yes, sir.
It looked like his work. I do. That's why. No offense.
No, give credit where it's due.
Indeed.
Your Honor, I will be respectfully requesting some modifications to it. If I could
We'll take a look at
work
them.
on it this evening and over the weekend and get with them and email it to them.
See if you can work it out. If you can't, uh, email me. You got my phone number. Everybody's got my phone number. Email me what you think. And that way I'm not looking at it cold when I walk in. Make sure if anybody's sending me anything that it's sent to everybody.
I will have this to them before 4 o'clock today and then
Well,
we
if
can
there's
communicate.
yeah, it comes down to 1 or 2 issues on the language, then I'll be available till later in the afternoon. If not, email it to me and I'll let everybody know ahead of time what I'm gonna